Okay, welcome back, everybody. This is part 2 of the Totality of Law class, and we left off talking about the common law versus the Roman civil law. And in a treatise on the law of judicial writs and process is one of the handouts in the mega links, and you find it by going to the common law, double-clicking on that, and then you'll go into common law process books with forms in April class. And then you'll go to a practical treatise upon the law of writs, 1895. So that's how you track that down and open it up. And so this is one of these books that when I read it, I was actually surprised about how much information it gave as far as the totality of law is concerned of everything. Now, I'm on page 63, so I'm going to make a note here, but I'm just going to scroll back up. I'm going to scroll back up to the top so you guys can get a look at the contents here. So, table of contents. History, definition, kind of process, chapter 1, historical introduction. Now, this is the fun. These are what I'm going to read from the historical introduction. But chapter 2, so what is process? So this particular treatise, we're going to spend a lot more time on in the April class. We'll spend a lot of the time on April class on this book. Regarding process is how do you get things done, and what is process, right? But for now, today we're just going to read the historical stuff so that we understand the difference of the different courts. But just to go through this, so how do you commence an action? What's irregular, incorrect process? Style or title of process, how you're supposed to serve people and what it's supposed to say. Direction and address. The teste, again, getting back to what we spoke about in part 1 about the etymology of that word. Why it's supposed to be in there, how it's supposed to be in there. The sealing of the process, meaning what? Meaning you're supposed to have your own seal, right? Which is the reason why we make sure that one of the first documents that we do in the Vocational Science of Freedom status doc process is the seal notice. So you get your seal done and you file it onto the public record and you establish your house. So once you establish your house seal, it also becomes the seal of your court of record, which is something that everybody used to know and everybody used to do. But somehow we got lost in history here and allowed the attorney to take away these important things from us. But we're taking them back one at a time. The signing of the process, right? Obviously got to sign it, signed, sealed, and delivered, right? The writ, meaning how to do writs. Various different types of writs. I'm not going to get into all of them, but you get the point. So it's a very extensive book as to how exactly to do everything at law, right? And so whom the process serves. Anyway, it just keeps going and going, but it's very, 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 very specific. So let me scroll back down here to page 63 and get going with the fun historical stuff here. So chapter 1, historical introduction. The Roman law, and let me bring back up our chart here. So the history of writs and process is essentially a part of the history of judicial procedure, right? Which is the map of all this craziness. The earliest type of which was a mock contest. Now this is Roman law, right? So this is Roman civil law. This is where Roman civil law started from. Each of the claimants laying hold of the object in dispute, thus symbolizing a conflict for the possession of the property in controversy. Okay, so say somebody sued somebody else, a neighbor sued to somebody else, said, hey, over a cow, say, you owe me that cow for whatever reason, doesn't matter. So they would literally bring the cow to the market court and they'd be both be hanging on to the cow, okay? This was called actio sacramentium, and seemingly for the reason that certain sum was solemnly consecrated to sacred purposes in pursuance of a challenge by each party to the other to stake a sum of money upon the truth of his assertion. Now what does that mean? What happened was that the two people would come with a certain amount of money, and they would solemnly, when it says solemnly consecrated to sacred purposes, they would literally swear to the god of whatever god they were swearing to help them in their cause, and then they would give the money as a sacrifice to the priest, right, who was overseeing the mock contest, and the priest would put the money into a locked chest, a case. This is where you get the idea that you've started your case. Okay? So anyway, with that, In this most ancient of proceedings among the Romans, the appearance of the defendant was voluntary, meaning he didn't have to show up. The state exercised no powers, save the magistrate interfered in the feigned quarrel by calling out to the disputants to let go their holds, thus interposing the authority of the state for the peaceful settlement of the controversy, meaning basically knock it off. Then the disputed question was referred to what? Arbitration. Okay? Roman civil law. Everything that is Roman civil law, arbitration predates it. Okay, there's a reason why Stark was able to, do what he did against the feds. There's a reason why we have our dock set up the way that we do, and why the Vocational Science of Freedom contracts for binding arbitration can bankrupt judges. It's because arbitration predates Roman civil law. You enter into a contract based on this as to, how it works under our contract is that if they end up administering any aspect of your estate, which you've already claimed, so you're over here, you've claimed your estate in natural and common law. If they try to administer any of it over here and any of this garbage, they agree to be entered into a contract with you to be put into binding arbitration, which would basically be something completely outside of all the rest of this garbage. It would basically be a little circle all the way over here by itself. So that you could pull them directly into binding arbitration. And the reason is because arbitration predates it. Okay? So, to continue. Though the decision was in favor of the plaintiff, yet the state lent no assistance to the execution of the judgment, except by permitting the defendant to be taken and cast into chains, refusing to treat such an exercise of force as unlawful, and punishing any resistance to it as a crime. So, guess what? The plaintiff was the one who went and put the defendant in chains and said, nope, I got you. You owe me, whatever. And you could do whatever you wanted to, literally, to him. Civil jurisdiction arose from the private arbitration of disputes. Make a point of that. Civil jurisdiction arose from the private arbitration of disputes. So everything that Roman civil law is based upon is private arbitration. That's where it stems from. So when we take these idiots into private arbitration, technically there's nothing they can do. Because, and here's the thing, if we want to go back this far, we, being the plaintiff, once we get the arbitration award, we don't technically have to have it confirmed. We could just go put them directly into chains. Literally. Now, there's another aspect in here which is going to be even more severe, but I'll get to that in a minute. So, the first judges were what? Merely arbitrators. The exercise of the power of the state developed from the voluntary submission of the defendant. Again, what does that deal with? Goes back to what Jefferson said. What is the just powers of government? Where are they derived from? The consent of the governed, right? And this became the cornerstone of the civil procedure in Rome. This is the absolute basis of Roman civil law. This is where it came from. This is what it was, what it still is, from a standpoint of being able to go to the top from the arbitration. So, that's the start of it. Now, this is what I was getting at before as far as the specificity of the time periods of Rome. Now, this is not important, but as far as what we're talking about, as far as the division of courts and classes and types of law, but it is kind of interesting as far as how Rome developed back and forth between starting off as a republic and eventually becoming an oligarchy and then basically a dictatorship. So 4 periods have been assigned to the development of Roman law. 1, from the foundation of the city to the time of the 12 tables. That's 750 to 450 BC. From the 12 tables to the birth of Cicero, that's 450 to 100 BC. From the birth of Cicero to Alexander Severus, that's 100 BC to 250 AD. And from Alexander Severus to Justinian, which is 250 to 550 AD. But in considering historically the subject of writs and process, 3 epochs only need be distinguished: the law of the 12 tables, the edicts of the praetors, and the imperial constitutions. I suppose I can read the rest of this. No, you know what? I think I'll skip this because this is more along the lines of, the rest of this gets into more process. But I just wanted to make sure that people understood the basis of how courts work, that binding arbitration, and like I said, binding arbitration would basically be a circle above all this stuff, outside of it, that once you put somebody in a binding arbitration by agreement and contract, there's nothing they can do to get out of it. So we'll just read this part because this part goes to enforcement. So the original means of enforcing a judgment by proceeding against the person of the defendant was ineffective where the defendant succeeded in escaping arrest, right? Because it's up to the plaintiff to bring what? The sword. That's why the sheriff, when you serve a writ of execution to the sheriff and says to him, hey, sheriff, on such and such a day, I'm going over to Fred's house because, I won the suit against Fred and he owes me, my horse back, right? So you go over to Fred's house on that day and the sheriff had better show up because you gave him a writ of execution saying, sheriff, come help me on such and such a day to be over Fred's house to take my horse back. You bring your sword, or in this modern age, your sidearm, and the sheriff is supposed to bring what? Well, back then, his shield. That's why the symbol of a sheriff is a shield, not a sword. Because the plaintiff is the one that was supposed to be bringing the judgment. Okay, nothing's changed, people. Nothing. You want judgment? Bring it. You have all the lawful authority to do so. Anybody that stops you, as it says clearly there, is the one who's violating the law. So, this led to the introduction of a supplementary process which authorized the plaintiff to take possession of defendant's entire estate. What? That's right. If the defendant didn't give you what he was supposed to be giving you, you got to take possession of his entire estate when he escaped arrest. It deprived the debtor of all right to enjoy his property and gave the judgment creditor the right to control and manage, and had the effect of bankrupting the defendant. You see how ruthless Roman civil law and the law merchant is in this system? No wonder why people, lose everything in this filthy system, because you don't realize what they're doing, and that this is how it was established to begin with. I mean, it's been like this from the beginning. It's not like it just grew like this. It was this harsh in the start of it. So this entitled the loss of the debtor's political rights and rendered him infamous. The enforcement of a judgment caused the defendant either imprisonment or bankruptcy. At length, judgment debts were enforced by direct seizure and sale of the debtor's good by public officials. Animals and movables were taken first before levying the land. Slaves, oxen, and implements of agriculture were exempt. The sale was conducted by the officers of the court. Right? Notice anything about that familiar to this day? Right? We're having an estate sale because somebody's bankrupt, right? Same thing. Such was the development of the process of execution, which was gradually legalized by the state and became, at the time of Justinian, a part of a regular judicial process, being fully transferred from a sphere of individual volition, that's the plaintiff bringing his own judgment, to the domain of public authority. Right? So, that's Roman civil law for you. The English law. Now I'm just going to read this because it's fun. The early judicial proceedings of the Saxons were consistent with the manner of the age. There were 4 kinds of trial, of which express mention is made: trial by ordeal, trial by compunctures, by witness, and trial by the duel of battle. Trial by ordeal was performed in different ways, the principal of which were by fire and water, the former for persons of free condition, the latter for villains. The fire ordeal was performed by walking barefoot over burning plowshares, as Queen Emma, the mother of Edward the Confessor, is said to have done, or by carrying a bar of red-hot iron. Right? Some pretty strange, barbaric stuff, right? The innocence or guilt of the party depended on whether the test injured him. Yeah, not having to do with physics or anything, right? In the water ordeal, the accused was denounced bound hand and foot and a rope tied around his body, and thus he was thrown into a pool. If he floated, his guilt was established, while sinking was proof of innocence. And probably death, too. So you're screwed either way. In performing the hot water ordeal, the accused plunged his hands into the water if the crime charged was not heinous. But if heinous, then the hand and forearm were submerged. Great. Innocence or guilt was, again, indicated by the results of the test being injurious or not. Trial by compugators was performed by the accused party bringing a certain number of persons who laid their hands on the Gospels or some other relic, and over the hands of the accused, laid his hands and swore that he was not guilty by the crime charged against him. By this act, the persons whose hands were laid on were supposed to declare on their oaths that the accused had sworn truthfully. Now, this is basically a standpoint of, here, just bring my witnesses with me now and say that I'm not guilty. That's basically what that comes down to. This species of trial was applied to civil matters in actions of debt upon civil contracts and was known as wager of law. Trial by witness was the obvious mode for determining the truth of a controversy and was much facilitated among the Saxons in civil cases by reason of the law requiring witness to every bargain. The historical note here, the Vikings also did the same thing. The Vikings had an interesting thing that they did, which they called the Wigamawot, and it was a calling of the people, which they did once a season. So all the Vikings basically got together once a season, and big party, and they took care of their business, took care of their courts and law and everything else, and they had witnesses, and the law was spoken by someone who was called a lawgiver or a law speaker, and it was recited every single season, and it was not written down, and then they went on about their business of doing whatever Vikings did. And the other thing that they did was the next one, and this is trial by duel or battle, was the most honorable and consequently the most common mode of determining disputes. It was being a superstition of the times that successful valor was the best truth and innocence, or best test of truth and innocence, sorry. This mode of trial was practiced in both civil and criminal matters. Such was the inception of judicial procedure in England, which progressed through trial by certificate, by record, the sectators, and the assize, to trial by jury. The trial of disputes was attended with but little formality. There was but verbal summons, disobedience to which did not subject the defendant to the harshness and severity of the Roman civil law. For good reasons, attendance was excused, and at times the court were sent to the parties, meaning the court would come and show up where you were at, and they'd do business there, which, strangely enough, became a continuation of that was what was then called which is where you get the idea of a circuit court, where the judges are supposed to go around on circuits and actually move around from courthouse to courthouse to courthouse. Now, they don't actually move anywhere anymore, but the reason we still call them circuit courts is because of this reason. It's because they did used to move around. So it was supposed that all persons in disputes were actuated by a principle of honor that rendered the coercion of the law not so necessary. So supposedly you're supposed to be under your honor and just show up. As questions of greater perplexity continued to be presented for determination, judicial proceedings became more formal. The oral summons was superseded by a written command to attend court and answer the complaint charged. They were called writs, were made out under the seal of the king, and were testade by the name of the judiciary. Following continued disobedience after service of 3 writs of summons, which was, now this is prior to that bishop that I just spoke of before, creating the subpoena, there was still a writ of summons, because the writs of summons actually existed, and I believe it was Marcus Aurelius that actually laid down the writ of summons in Roman civil law. So there was a way of summoning people before they did the subpoena writ, right? So what the writs were called, there was an original writ, a pluris writ, and then I believe a final writ was how they did the summons. And so then, so they did the 3 writs, and then the land of the defendant was taken. So disobedience after summons of 3 writs, the land of the defendant was taken into the king's hands and was, after 15 days, adjudged to the complainant. So in a way, they kind of followed the same aspect. And of course, they probably did get it from Rome, because Rome did rule over England for a while. And to this day, the city of London is still private city-state, a private Roman city-state. It was laid down in 43. This is just some side history for everybody. The city of London was laid down in 43 AD by the Romans, and it's always been a Roman conclave, and that's the reason why to this day that the Queen doesn't own it, and why she has to basically ask permission to enter the city of London, which is, of course, where the Bar Association is. Surprise, surprise. So to continue, the wording of the writ was varied according to the nature of the injury for which the remedy was sought, and in consequence received a variety of applications according to their object and occasion, and have amounted in number and approximately 150. So there was a lot of different writs at one point, but few of which are now in use and are to be written of in this treatise. So that's English process for you. I'm not going to read the rest of it, but again, then it gets into more specific into writs and whatnot. But I just wanted to show you the different times of how the two things kind of started off, just for a little bit of history. So now let's go back to the handout. We have the two origins of man's law. We've got common law, which is real aspects of customs of the people. It deals with the lodial title instead of Roman civil law being the aspect of use and usufruct. As I read before, it said the term is in contradistinction to equity, admiralty, and maritime law. So there is a clear distinction between common law and these other things, which they try to drag you into. So when you do your superior court of record, you are definitely over here. Statutory law, that which deals with fictions, like corporations, regulates commerce, consists of statutes, acts, ordinances, and codes, created with first codes of man, going all the way back to Code of Hammurabi, and the date is something like 1789 BC, I believe is what it was. So just to make a note of that. And also the 12 tables were one of the bases of Rome, and the date was in the treatise that I just read, so you guys can double check that. So statutory law is made by legislature that only has delegated authority to write certain laws as per a constitution or royal decree in England. So if a legislature doesn't have a decree or a constitution to stay within the bounds of to write something, meaning they write something, or to put it another way, if they write something outside the bounds of the constitution, it's not law. And that's clearly stated in all kinds of various different court cases, including probably most famously Marbury versus Madison. But you'll find cases like Marbury versus Madison for each state as well. So let's get on to this war, basically, that's been going on between common law and Roman civil law. And the reason why the people of England never fully succumbed to the filth of Rome was because they believed in loving their culture and loving themselves to the point where they weren't going to be turned into slaves. A important lesson that I think should be spread far and wide now in our day and age, because there is a great divide happening right now between those that are aware that something is wrong and those that have no idea that anything is even going on. And that huge difference and huge divide is something that really has to be understood as to why it's happening. So I gave a link here of a very short little synopsis of the difference between Rome and what the more advanced peoples of Europe, and why they were fighting against Rome, and why Rome was trying to do everything it was trying to do and to conquer them. And you can watch it here, but it's called The Consequences of Cowardice. It's a really good look at why Rome is what it is and why it's just a perpetuation of slavery. I mean, really, you really think about it. There was really only two things the Romans were good at: keeping slaves and then keeping records of those slaves, basically. Everything else they stole. There really isn't anything that the Romans originally did at all, aside from their fascinations with keeping ledgers and, creating and writing all this stuff down that was theirs. I mean, their gods were all Greek, so they just renamed them. Their beginnings of their laws and the ideas were all Greek. They just stole them. Their language is Etruscan, mirror reversed, in case anybody doesn't know that. And then they called it a cursive language on top of it. So they broke their vows. And in fact, the whole entire Roman culture was a continuation of a nasty little Luciferian human sacrificing tribe called the Yahudi. But, and that's another secret that a lot of people don't know about, that connection is there, and that's why everything that comes out of Rome is just absolute scum. As far as I'm concerned, it should be now what it is now, the Vatican, under ecclesiastical law, needs to be tried for all of its crimes for thousands of years, as far as I'm concerned, and the whole thing should be taken down. And as far as the law is concerned, we should return to what the Founding Fathers knew to be what we should be doing, which is creating our own law in our own courts, in courts of record. But I suggest that everybody take a look at that and watch that video at least once. It's a really good layout as far as what's been going on as of late. So we covered the 100 Court. Let's open up the Grand Jury Manual, which is a chapter out of the Grand Jury Manual, which I've written, but I need another editor. It's basically what I need. There was a time when Michael Badnarik was editing it for me, but so I still need an editor for this thing. But anyway, now we'll start down the 5 jurisdictions of Anglo-American jurisprudence. Okay, so this is what we are supposed to be doing, and the things and how our courts are supposed to work. So the 5 major jurisdictions of law and a brief history of their origin. Ignorance of the law excuses no man from practicing it. Isn't that the truth? So to understand the 5 jurisdictions of law in America, in the American republics, let us first learn the proper definition of that word. Okay? So now this is from Black's. Okay, so this is Black's second. This is the definition. Jurisdiction, the power and authority constitutionally conferred upon or constitutionally recognized as existing in a court or judge. So is the judge the court? Nope. So can there be a court without a judge? Yep. To pronounce the sentence of law or to award the remedies provided by law upon a state of facts, proved or admitted, right? So you admit, I admit, you admit facts onto the record, referred to the tribunal for decision, and authorized by law to be the subject of the investigation or action of that tribunal, and in favor of or against persons or a res, meaning like a thing. A res is a thing. So you can have suits which are John Doe versus 200 bales of cotton. That's perfectly legitimate in some of this crazy stuff over here. Or you can have John Doe versus the Mermaid, which is some ship, the name of some ship, right, under Maritime Admiralty law, who present themselves or who are brought before the court in some manner sanctioned by law as proper and sufficient. Okay, so to kind of cover this a little bit, referred to the tribunal for decision. So I'm going to open up another doc here real quick, and it's courts and courts of record. It'll be just in the handout folder. It'll be the bottom document, courts and courts of record. So open that up real quick. So I want to show you what a court is. So a court, the person and suit of the sovereign, the place where the sovereign sojourns with his regal routine, wherever that may be. So, what's a court? It's the sovereign and his suit. It's not the judge. It's not the district courthouse. It's not the bailiff. It's the sovereign and his suit. That's the court. By the way, this suit used to be called suite, or it used to be an E on here. It used to be pronounced suite. And the suite was just the people that followed around the sovereign, remembering what happened in his court that day, wherever his court may be. Okay, so it's the next definition of a court. So court, an agency of the sovereign created by it directly or indirectly under its authority, consisting of one or more officers, established and maintained for the purpose of hearing and determining issues of law and fact regarding legal rights and alleged violations thereof, and of applying the sanctions of law, authorized to exercise its powers in the course of law at times and places previously determined by lawful authority. Black's Law, 4th edition. Okay, so that's a court. So from here, go back to this, the aspect of jurisdiction, referred to the tribunal for decision. Okay, what's the tribunal? Now in a court of record, right, in a common law court of record, the tribunal, so here, the tribunal is independent of the magistrate. So this is a court of record. All the definitions of a court of record. I should pull this over a little bit. There we go. A judicial tribunal having attributes and exercising functions independently of the person of the magistrate assigned generally to hold it. So, if the magistrate isn't the tribunal in a court of record, who is? Well, if you have 12 members of the peerage, it's them. It's the petit jury. If you were before the full grand jury, it would be the 25 members of the peerage sitting as the full grand jury. But if the defendant doesn't demand a jury, guess who the tribunal is? It's not the judge, because there isn't even a judge in a court of record. There's only a magistrate. It's the sovereign plaintiff. The sovereign plaintiff is then the tribunal and will determine what happens in the court, will determine whether a motion gets passed or not, and that magistrate had better check with that sovereign whether they wanted to have that motion granted or not, because it's up to the sovereign to determine, not the magistrate, as you can clearly see by that definition. Now, from the understanding of that the magistrates, right, are not judges, and that they are under our control, and the foundation documents of law, go down to the Virginia Declaration of Rights. Open that up real quick. Number 2. I'll read number 1 and number 2, but it's number 2 is the point. So Virginia Declaration of Rights, June 12th, 1776. 1. That all men are by nature equally free and independent and have certain inherent rights, of which, when they enter into a state of society, they cannot, by any compact, deprive or divest their posterity, right, the right of their heirs, namely the enjoyment of life and liberty, with the means of acquiring and possessing property, and pursuing and obtaining happiness and safety. Sounds good? Number 2, that all power is vested in and consequently derived from the people. That magistrates are their trustees and servants, and at all times amenable to them. You are my servant. You are a trustee. You are here to perform what I tell you to perform. Failure to do so will result in me holding a contempt hearing against you, because you're in contempt of my court, because you're not understanding who the power is here. Who's your master? I am. You are a servant, you fool. You try and act like a black-robed priest of El, I'll take your head off. This is the attitude that everybody needs to have in their own courts of record. These scumbags have been running around for hundreds of years, stealing everything from everyone, because we're not doing what we need to be doing over here. Particularly forming grand juries and indicting them for their treason. Now, anybody that happens to be listening in Virginia, guess what? You could literally take any of these fools once you created this court, and if they did anything opposite of this, you could hold them in treason of Virginia. Can you do that? Yes, you can. There's certain constitutions in certain states that even have a whole layout for it. Iowa's one of them. Iowa says that you can be held in contempt or held for treason against Iowa, against the state of Iowa. Not that anybody's ever done that in a while, but I think it's probably a pretty good idea to start doing it now. Particularly with all this voting fraud. Hold them in treason against the state. Just hang them. You hang 2 or 3 people, trust me, all the rest of these communists will get the picture real quick. And I will have absolutely no compunction or problem with that at all. In fact, I'll pull the lever. It's fine. I'll put on my little, black mask and be the death man. Not a problem. Get rid of them. You want to have your republic back? This is the only way. You cannot be weak. You cannot be timid about anything that you do. You have to understand your power. You have to understand that you are sovereign, and you have to put these fools in their place. Failure to do so will render you as a slave for the rest of your existence. As I think it's clear in this day and age that that's exactly what's happened. as Mark Passio goes on and on about, the main situation of the entire planet is that what needs to be removed from this common aspect of slavery of people, because we're in a state of ignorance, is the reason why you are a chained, ignorant slave. Until you learn this, all of it, there's no way that you're going to be able to get out of it, save from just simply going full out revolution, which they're pushing everything for with their dual-sided media and their left and right paradigm. Don't pay any attention to it. There's only one truth. Have you caused damage, harm, loss, or injury? Well, if you have, you're going to face a court of record. And damage, harm, loss, and injury against the Republic, that's called treason. Again, guess what the penalty is for it? Death by hanging. So get back to the court of record. A judicial tribunal having attributes and exercising its functions independently of the person of the magistrate designed generally to hold it. You got all this case law here. B, proceeding according to the course of the common law. Superior courts proceed according to the course of the common law, not according to statutes, acts, ordinances, and codes, UCC, law merchant, Roman civil law filth. Got it? C, its acts and judicial proceedings are enrolled or recorded for perpetual memory and testimony. Keeps a record. Great. D, has power to fine or imprison for contempt. As I said, if the stupid little magistrate wants to get out of line, hold a contempt hearing. Say, hey, I'll give you a chance to, argue your side. What makes you think that you have any authority to determine or to be a tribunal in this court of record? Answer me. Oh, you can't? Good. You can go sit in jail for a few weeks. Think about it. Mull it over a little bit. While all the rest of your colleagues run in terror from the fact that we control this nation. Anyway. E, generally possesses a seal. So, where does the seal come from? It's not the county. It's your court. Better be your seal. That's why it's important to make your own seal. And as I covered before, very interesting little thing, which I'm not going to bother to go dig up right now, but another interesting little thing regarding history and seals is in the 1818 Illinois Constitution, all the way at the bottom in what's called the schedule, which is the part of the Constitution that says, okay, now that we wrote this thing, how do we get all this stuff done, right? So in the schedule, it specifically states in the 1818 Illinois Constitution that the governor of the state of Illinois, because of course they had no idea who was going to be elected, the governor of Illinois will use his private seal until a state seal can be provided. Well, that's interesting. So that means in 1818, because they didn't know who was going to be governor, but they knew the fact that in 1818, whoever it was going to have their own private seal. Where the hell did that go? It's just something else that these attorneys have stolen and destroyed as far as the importance is concerned. And the other aspect of a seal is that when you seal something in regards to, say, like a contract, and both of the parties sign, seal, and deliver, that's called a covenant. And a covenant is a stronger thing than just a regular contract when it's sealed. So just a little point on the seal there. Okay, so that's your court of record. And, to continue, the word magistrate does not necessarily imply an officer existing any judicial functions, right? Which is why it's specifically stated that way in the Virginia Declaration of Rights, that it's magistrates, that magistrates are their trustees and servants, right? So, and this is an interesting aspect of a court of record, that no statutory or constitutional court, whether it be an appellate or Supreme Court, can second-guess the judgment of a court of record. The judgment of a court of record whose jurisdiction is final is as conclusive on all the world as the judgment of this court would be. That's the Supreme Court talking, by the way. It is as conclusive on this court, meaning the Supreme Court, as it is on all other courts. It puts an end to inquiry concerning the fact by deciding it. Right? Because why? Because of what I read before in the federal Constitution, where it states that no matters decided by, right, a court of record can be overturned except by what? The common law. So the acts of a court of record are known by its records. Judicial records are not only necessary but indispensable to the administration of justice. The court judgments can be evidenced only by its records. The acts of a court of record are known by its records alone and cannot be established by parole testimony. The court speaks only through its records, and the judge speaks only through the court. So what does that mean? It means what gets put down into the record, people. If you don't file what you need to file, if you don't put the evidence in, well, guess what? It's not there. If you do not object to something that you don't like going on in your court, guess what? There's going to be no record of the objection. So you don't have anything to stand on. But once you object, you can say, hey, objection. And the judge will say, why do you object? Well, it's not my wish. Now, it sounds like you're talking very silently or very quietly, like softly. But a wish, when spoken from a sovereign, is the subject's command. That's ancient law and truth. It's just ancient, absolute truth. So when you say that, you say, it's not my wish that you grant that motion. That's all you have to say. You don't need a reason. It's your court, so act like it. So to continue, inferior courts are those whose jurisdiction is limited and special and whose proceedings are not according to the course of the common law, right? So not a common law court, not proceeding according to the course of the common law, they're inferior courts. So this is where we get here. Inferior courts not of record. All this stuff is all inferior courts not of record. Superior courts of record are over here, right? And then courts martial are just for military. And then appeal courts and supreme courts are above the other inferior courts. Now they could deal with common law a little bit. These guys could. Not the inferior courts, but these guys could. They could deal with the common law a little bit because you can have original jurisdiction in high prerogative writs in state supreme courts, like habeas corpus and quo warranto and things of that ilk. So the inferior courts are whose jurisdiction is limited and special and whose proceedings are not according to the course of the common law. So that's where the difference lies, right? So when you're in a superior court of record, then you can do these various different things at law that you cannot do in inferior courts, okay? And the reason is because in inferior courts, you're subject to all of these statutes, acts, ordinance codes, basically by contract, by consent, that you've entered into these inferior court jurisdictions by some previous contract or by some previous agreement. And courts by previous agreement are called nisi prius courts, or courts by contract. Okay. And so here's an example of talking about courts of law and courts of record in the 1818 Illinois Constitution. So Article 2, Section 25. No judge of any court of law or equity, right? So we're clearly delineating here between common law and equity, or Secretary of State, Attorney General, Attorney for State, Registrar, Clerk of any court of record, Sheriff or Collector, member of either House of Congress, or person holding a lucrative office under the United States, or this, provided all those things are not lucrative offices, shall have a seat in the General Assembly, nor shall any person holding any office of honor or profit under the government of the United States hold any office of honor or profit under the authority of this state. Now that's getting close to the idea of the original 13th Amendment, but they're just simply differentiating it between an honor of profit that you can't be basically working for the United States federal government and the state government at the same time. So if you've got any questions about is there any courts of record? Well, it says right there, clerk of any court of record. Okay, great. So right in the beginning, there you've got it. The terms equity and chancery, court of equity, and courts of chancery are consistently used as synonymous in the United States. It is presumed that this custom arises from the circumstances that the equity jurisdiction, which it exercised by the courts of the various states, is assimilated to that possessed by English courts of chancery, which we already covered. So you can see how they all come together. We take all of these things, all of these terms from England, okay? So that's why it's important to know your history here. To constitute a court of a superior court to any class of actions within the common law meaning of that term, its jurisdiction of such actions must be unconditional, so that the only thing requisite to enable the court to take cognizance of them is the acquisition of jurisdiction of the persons of the parties. So, serve them your common law suit at law by process server. That's it. Your court has jurisdiction. They got served. This is the aspects of courts and courts and record. You guys can use this as a little reference guide. It's part and parcel of a section out of my much larger law of the case, which is on the Vocational Science of Freedom online library. So that's courts of record. So now that we've done courts of record, now let's get back to where we're at in jurisdiction. So to understand the 5 jurisdictions of law in our American republics, let us learn the proper definition of that word. So we read what jurisdiction was. Now, let us read the definition of the word jurisdiction from Bouvier. So this was Black's, right? This is Black's, I think it was Black's second. And so now this is Bouvier's definition. So jurisdiction, practice, a power constitutionally conferred upon a judge or magistrate to take cognizance of and decide causes according to law, and to carry his sentence into execution. The tract of land or district within which a judge or magistrate has jurisdiction is called his territory, and his power in relation to his territory is called his territorial jurisdiction. Now, again, when you have the aspect of a magistrate, is it his jurisdiction? No, it's the sovereign's jurisdiction. The magistrate is just holding the court. He's basically the referee in the middle of it. But he has to obey the sovereign law, right? As we already saw. Every aspect of jurisdiction exercised by a judge without his territory, either by pronouncing sentence or carrying it into execution, is null. An inferior court has no jurisdiction beyond what is expressly delegated. So, inferior courts is all this garbage. So what does that mean in thinking of the opposite of that? It means the superior courts of record have total jurisdiction. They're without bounds. They're not bound by anything. So, important point. Jurisdiction is original when it's conferred on the court in the first instance, which is called original jurisdiction, or it is appellate, which is when an appeal is given from the judgment of another court. Jurisdiction is also civil, where the subject matter to be tried is not of a criminal nature, or criminal where the court is to punish crimes. Some courts and magistrates have both civil and criminal jurisdiction. Now, what are they getting at? Okay, mostly everything that you do at common law is a crime. It's all a tort of some sort. And what's a tort? A tort's a harm. What's a harm? Some sort of theft, right? So again, you get into, it's all criminal. Everything they've done has been criminal. Over here, right? Because it's all an aspect of a harm and a theft. So some courts and magistrates have both civil and criminal jurisdiction. Jurisdiction is also concurrent, exclusive, or assistant. Concurrent jurisdiction is that which may be entered by several courts. It is a rule that in cases of concurrent jurisdictions, that which is first seized of the case shall try it. So basically what that means is that whatever one of these courts grabs it first gets to hold it, and the other ones aren't going to step on their toes. Exclusive jurisdiction is that which has alone the power to try or determine the suit, action, or matter in dispute. Assistant jurisdiction is that which is afforded by a court of chancery in aid of a court of law. Well, yeah, again, that's, remember, Roman civil law, use and usufruct, getting into screwing around with common law. As, for example, a bill in discovery by the examination of witness, or out of the jurisdiction of the court by the perpetuation of the testimony of witness and the like. So yeah, you see in American jurisprudence that how the attorney has made it so in statutory law, because obviously all the quote unquote legislators, all the legislators are all attorneys. So of course they legislate and create law to make it so that they control the system. No surprise there, right? So what we have to do is we have to control our own system and say, be gone with you. which then will have original jurisdiction and also a lot of the times exclusive jurisdiction to try things like treason. Right? It all goes over here. So number 4, it is the law which gives jurisdiction. The consent of parties cannot therefore confer it in a matter which the law excludes. So what is that getting at? So if I'm in a common law, or if any of us are in a common law jurisdiction, right? I have no contracts with the corporate state. I'm traveling down the roads and highways which belong to me in whatever property I feel like, whether it's my bike or a motorcycle or whatever, doesn't matter, or a 18-wheel truck, doesn't make any difference. So I'm in a common law jurisdiction traveling along the road, right? So some cop comes up and says, get out of your horse and buggy or whatever. If I'm not engaged in commerce, the law which gives jurisdiction doesn't exist. And as it says there, the consent of parties cannot therefore confer it. So you don't have any jurisdiction to stop me because I'm not engaged in commerce. I'm exercising a substantive right protected under the federal and state constitutions, under the right, and the Declaration of Independence, truly, under the right of life, liberty, and the pursuit of happiness. I have the right to pursue happiness by traveling down the road. Hey, I want to go to the lake. I have the right to do that. And there's nothing that you can do to stop me. Save pull a gun on me and say, pay me, like a land pirate that you are. Right? But the point being there is that the aspect of jurisdiction, the consent of the parties cannot therefore confer it in a matter which the law excludes. And trust me, when it comes to traffic, it's definitely excluded. Because the terms are very specific. But, again, the terms get into all of this side of the filth of how they've redefined terms, which I'll get into much more in April when we go over the process class of everything that goes on in these courts. So, but anyway, to continue. But where the court has jurisdiction of the matter, the defendant has some privilege which exempts him from the jurisdiction. He may waive the privilege. So that's basically the aspect of if you don't exercise it, you lose it. So I'm trying to think of a way that this would pop up, but basically what this means, I won't try to think of an example, but basically what this means is that if you have a way to say that, hey, I'm exempt from the law, and you don't bring it up, well, then that is kind of an aspect where you may waive the privilege, but it has to be an aspect where you are privileged. And from an aspect of privilege, sovereignty is a privilege. I mean, it's a privilege that you have from being exempt from filthy inferior courts, not of record. So yeah. So number 5, courts of inferior jurisdiction must act within their jurisdiction, and so it must appear on the record. And there's a lot of case law there for that. So you get stuck in front of an inferior court as a defendant. The first thing you want to do, of course, is make yourself a plaintiff. But aside from that, first thing you do, challenge jurisdiction. It must appear on the record. Your Honor, I demand that this court produce the facts that this court has passed on jurisdiction, or that the matter regarding jurisdiction has passed, or that the court has passed on the matter of jurisdiction. However you want to state that. You can state it all kinds of different ways. Past, meaning past judgment, meaning that it's been proven. Where's it been proven? You can always ask, and that's the point. You have to bring it up on the record. Must appear on the record. Your verbal voice is the record. That's fine. It's always better if you take a few witnesses and it would always be better if you take a tape recorder and record everything that you say, because the court reporter will lie. They will change things. I've had that happen numerous times. Enough to know that it's not a coincidence. So, anyway. So to continue. But the legislature may, by a general or special law, provide otherwise. Okay, fine. And the art competency as to the force of municipal law beyond the territorial jurisdiction of a state. Yeah, okay. So that has to do with like aspects of home rule, like what a city can or can't do beyond the jurisdiction of the state. So, or sorry, beyond the territorial jurisdiction of the state. So when you enter into a city, are you actually under, various different municipal law, Roman civil law? Okay, so that'll leave that there. So that was the definition that was the end of the definition from Bouvier's regarding jurisdiction. So now this gets into my language, which I'll kind of skip here, because I want to get down to Corpus Juris Secundum, Volume 7, Section 4, Attorney and Client. Their attorney's first duty is to the courts and the public, not to the client. And whenever the duties to his client conflict with those he owes as an officer of the court in the administration of justice, the former must yield to the latter. Clients are also called wards of the court in regard to their relationship with their attorneys. Any questions? If you hire an attorney, you are an infant. You cannot deal with your own affairs, and they will run you over, because nothing you say will matter. Because they can't hear you. Because an infant doesn't have a voice. An infant can't hold title. An infant can't claim title. So where does that leave you? Well, leaves you in a serious problem. So be a plaintiff in a superior court of record. That's the point. So, okay, so now we get into the 5 jurisdictions of law. So let us consider each on their own and how they differ from each other. It should be noted that, as above mentioned, there are many ways which law is divided, obviously. This division listed below to the jurisdiction, not to systems of law or origin, which is what we'll get into. So, skip down here. The different kinds of law above mentioned are administered in 5 classes of courts. So, namely, courts of law, which means common law, and are referenced to as at law, quote unquote at law, in the constitutions. These courts deal in reality, not fiction. The litigants are men and women of a particular status, and there is no judge, there is only a magistrate. And the tribunal, the entity that does the judging, is separate from the magistrate. The tribunal is either the jury of 12 members of the peerage or the sovereign plaintiff. These courts are called courts of record and are always superior to any other court, even the Supreme Court of the United States. An opening paragraph for a suit in such a court could be as follows. Comes now, Eric Jonas, a man, one of the people of Illinois, having come of full age, hereinafter plaintiff. And in this court of record, calls upon Dan Lee, a man who is one of the people of Wisconsin, who has come of full age, hereinafter defendant, to answer plaintiff in an action of trespass and trespass on the case to wit, and then off you go. 2, courts of equity, also called chancery, right, which we talked about. These courts require a trust relationship or contract to be placed before them in order that they be given jurisdiction over a matter. You don't have any capacity of equity if there's no trust, if there's no trust relationship. Now, a contract can be a trust relationship, right, or a form of a trust relationship. When you do a harm, you can put it into tort directly under common law. You don't have to go through equity or chancery, right? So these courts deal in fictions of law and use and usufruct issues. The administration of infants and their estates, right, that's under ecclesiastical law. Contract issues, trusts, corporate matters, and matters that are exclusive to equity courts. The litigants are men and women or fictions of law. There is a judge, also called a chancellor, and litigants pray to his conscience for him to rule for the parties for what is equitable for all parties. In an equity court, the judge shall, as per judicial canon, see evidence and rule accordingly, even though they rarely do that. Statements not supported by fact should be objected to and are inadmissible if they come from a party that has no first-hand knowledge of the facts. That's called hearsay. So somebody comes in, they say, yeah, so-and-so, somebody else, some else so-and-so said such and such. That's hearsay. And you should object to that. So it's off the record, or at least you can appeal it later, that if they do use it against you, that you can appeal it and say, hey, appellate court or Supreme Court, these guys were using hearsay. Can't do that. If it was in your superior court of record, you just move to strike it. So you say, move to strike. That's hearsay, right? And of course, if the magistrate were to overrule you in your superior court of record and you were the plaintiff, well, then you could just say, well, Your Honor, for the record, I do object. And then you do a writ of error later and fix it. You just fix the record, correct the record. The magistrate had no place to overrule the sovereignty of the court. So, if a judge operates outside of judicial canon, the court may be condemned as non-existent, for he would cease to be a judge or chancellor, and therefore it would cease to be a court of quote-unquote equity. An opening paragraph for a suit in such a court could be as follows. Comes now James C. Smith, notice it's all caps, hereinafter plaintiff, and complains of City of Tampa, a municipal corporation, hereinafter defendant, and summons the defendant to answer plaintiff for violation of Florida statute, whatever, and alleges. So you have an allegation, right? In equity, you have allegations. Equity and ecclesiastical law, you have allegations. In common law, you have inside the action, you have what's called a declaration. So you file your action at law, but inside your action at law, you have a declaration. And in these two, you have an allegation. Or in statutory law, you have a complaint also. So, number 3, courts of admiralty are courts which administer banking and merchant affairs and maritime law. All insurance contracts are considered to be maritime admiralty contracts. So remember that. Regardless, it should say if they have anything to, that's why I need an editor. Regardless if they have anything to do with the sea or not. They are so called because anciently the admiralty was the judge. So that's why you have maritime admiralty courts. These courts deal in fiction of law. The litigants are men and women, or fictions of law. The judge, being the captain of the ship, has total control of the proceedings and can create law from the bench. An opening proceeding for a court in such a suit could be as follows. Comes now the East India Trading Company, hereinafter plaintiff, and brings Mary Lou, a vessel owned by the Virginia Company, before this court of admiralty, and places a bottomry bond upon said vessel for an outstanding unfulfilled bill of lading, and alleges the following. You could also call it a droit. Though they're also called droits too, but it depends what you're actually doing in maritime admiralty if it is an actual droit. Number 4. So here we go. So that's your courts of maritime admiralty, right? So number 4, courts of military down here deal with courts martial, and these courts require that litigants be members of the military and deal with disciplinary actions of who they are. Meaning, if it's Navy, then it goes to naval. If it's Army, it goes to Army, so on and so forth, right? And I've never seen an original court martial filing, so I can't give an example of it. Number 5, an ecclesiastical courts, which still to this day, for reasons unknown to this author, deal with probate matters and the distribution of property, land, and possessions of people who have passed on. And that's obviously probate matters are still aspects of that. So the common law, again, so now we'll go back to the separate definitions and distinctions of the common law. So the common law, the substantive definition of common law is that set of rules which a people are governed by on the land from usage and customs. So land, sea. Maritime admiralty, sea. Common law's land. As defined of common law was originally cited from Bouvier's Law Dictionary edition. Let us now look at the definitions of common law from Black's Law Dictionary, 2nd edition. So common law, as distinguished from what? Roman law. Even though I don't put the civil part in there, that's what it is. The modern civil law, the canon law, and other systems. The common law is that body of law and juristic theory which was originated, developed, and formulated, and is administered in England, and has obtained among most of the states and peoples of Anglo-Saxon stock. As distinguished from law created by the enactments of legislatures, the common law comprises the body of those principles and rules of action relating to the government and security of persons and property, which derive their authority solely from usages and customs of immemorial antiquity. So this goes back to before there was written law. So when you talk about immemorial antiquity, that these customs and usages of things that are wrong to do and the punishments for them, that's where you get into the aspect of the unwritten law as well, meaning the true law. And this would also include the Magna Carta. Or from the judgments and decrees of the courts recognizing, affirming, and enforcing such usage and customs, and, in this sense, particularly the ancient unwritten law of England, which I just mentioned. So, and this would include allodial land title. So this is the huge difference between where you have a action at law for allodial title of land and a complaint in equity for the use of it, or for, say, property tax issues, right? Because you're in a fiefdom. So anyway, 3, as distinguished from equity law, it is a body of rules and principles, written or unwritten, which are of fixed and immutable authority, and which must be applied to controversies rigorously and in their entirety, and cannot be modified to suit the particularities of a specific case, or colored by any judicial discretion. Notice that. Or colored by any judicial discretion. What does that mean? Under common law, there is no judicial discretion. They can't do they can't do anything about it. There's no discretion here. Jury says that's it. Sovereign says that's it. That's it. So, 4, as distinguished from ecclesiastical law, it is the system of jurisprudence administered by purely secular tribunals. 6, in a wider sense than any of the foregoing, the common law may designate all that part of the positive law, juristic theory, and ancient custom of any state of nation which is of general and universal application. That's why you get the crossing over of this, that, this, law of nation, all of it. That's why it just gets all connected in here, all these little pieces. It all has a little part of all the rest of it. So that's that. So you're right that common law are separate and superior to statutory enactments and penal codes that govern persons, infants. A common law action of trespass with arms is indeed a criminal prosecution. However, criminal here refers to the general actions of a state to prosecute those in the state for crimes of all of the people in the state, i.e. a grand jury. And that's when you do a grand jury indictment, it'll be named in the beginning of the indictment, it'll say, in the name of the people of the state of Illinois, or in the name of the people of the state of Michigan. That's how you start a grand jury indictment, because it's in the name of the sovereignty. Who's the sovereignty? We the people. And just make a little note here for anyone who might be listening who does not know this. If you look up under infants, if you look under 1 USC, subsection 8, under the definition of person, what you'll find is that a person is defined as an infant. So you can go look that up and see that that's exactly what's going on. So that's where they're governing infants, right? So I'm going to skip some of the rest of this because, like I said, some of the rest of this has to do with, a lot of it has to do with process. So I'm going to skip that, and it goes through some of the other stuff that we've already covered today. Okay, so down to equity. So we did common law, so now let's get on to equity. So equity, the jurisdiction of equity was developed out of the King's Bench in England, which was a court of record, and was a way for the king to keep litigants coming to his court so he could collect fees, which is what I explained what King John was up to, and to adjudicate issues which a suit at common law may not fully be able to bring justice. This so-called failure to bring justice was mostly from the idea and introduction of uses, which was a concept foreign to the common law and which has its roots in Roman civil law and was growing in applicability in England by, of course, the attorney, right? So that's where you get that use and usufruct coming in there. Passage shall now be given detailing the description of the creation of the jurisdiction known as equity from an elementary treatise on the common law by Henry T. Terry, 1906. Now, this is what I already read, so I'm not going to reread this. So we already did this. And so that was equity. So we already reread that. And so as we see above, equity is where you go before one man, usually attorney, in a black robe, pray to him, submit yourself to his conscience with no protection from a jury of people from the area you live, and who could, if you were the defendant, summon you as if you were a dead entity. Rather creepy, summarized in that way, but as stated above, completely accurate. It is no wonder why the people of the colonies wish to create a system of justice based on the common law and natural law rights, and not equity, also known as chancery, stemming from and created by the overreaching power of the attorney. The modern statutory system is an even more distorted version of equity. This is an even more bastardized version of equity where the courts bring a for-profit corporation, listed on Dun & Bradstreet Credibility Corporation, that'd be dnb.com, is a for-profit business that by judicial process administers your estate by presumption of death, probate, and treats you as a trustee of your own body. No more corrupt and evil a system of uses could ever have been devised. It literally turns every man and woman into a prostitute for the state, whilst deriving a profit off of your head, cap, which is a system we call capitalism. Admiralty, I think I read most of this, but let me check here. Yeah, gets back into what we read from Admiralty, which I already read from the treatise. And Ecclesiastical should have been the same thing. Yep, so Ecclesiastical gets into the same thing that we already read. So I'll get down to canon here. Okay, so again, all the power goes back to the attorney. That's all the other things. It warrants mentioning that the history of England to be raised by the attorney in all the aforementioned passages is the same thing that we're facing here in our American lands. What evil can take by force of arms by miles in a matter of months, they steal by deception of the attorney by inches over years and decades. So, and that's the aspect of the understanding that what we won by force of arms in the Revolutionary War, it took the Khazarian mob and the British Empire decades, hundreds of years, to take back by force of insight and force, fraud, lies, and coercion, which, if perpetuated over that length of a time span, is just as detrimental, as I just mentioned, as a gun in your face and the sword. So, but it also means that there's actually a silver lining in that. We, the American people, still own more arms than all of the entire militaries of all of this entire planet combined. That's not a joke. That's a real statistic. And knowing that, there's never been a time at all that we couldn't have said, all right, enough's enough, by force of arms, and just fixed all this. The lies perpetuated by the attorney and media of some idiot idea that, oh, we're going to come take this from you, we're going to come take that from you, from a stupid, brain-dead moron who's had brain surgery and is a pedophile, meaning Biden, is lunacy, absolute lunacy. If that even were to begin to happen, I can guarantee you that not only would all of the veterans, particularly special forces, would instantaneously start to train everyone else to say, nope, that's not happening, and be done with it. But the fact that the militia is an aspect of having, what militia actually means army everywhere, and that we can always come down on any of them for trespass upon any of our substantive rights anytime we want to. The trick is, and what I'm trying to teach everyone, is that there's simply a proper way to do it. And there's no reason to be scared about it because you have all the power anyway. You have all the arms. You're the only one that has the sovereignty. And no one is going to get in our way. No one. Trust me. I've been in protests with armed protests, walking down the street with hundreds of other people that are armed. They don't do anything. They just get out of your way. And of course, you're being peaceful about it anyway, so it doesn't matter. But it's only when you get idiots, and I'll get into this. Well, maybe this might be a good, military's right here, so I'll finish up with Ken. I'll get into this in a second. The aspect of insurgency and the understanding of insurgency, of what the federal government has been doing as far as insurgency, to hire insurgents, make them appear as though they are us, and then try to make it sound as if there's it's a horrible thing that they're doing and they don't have the right to do that and it's unlawful and we're going to do this to you and do that to you. Well, do it to who? The people you hired to go out there and perpetuate this bullshit? Great. I'd love to see that. But you're not gonna, because we know that you bail them out. Right? You know that Soros bails everybody out from a standpoint of doing common law crimes, right? The destruction of property, rioting, looting. Those are all common law. It's all theft. So they all get bailed out when it's conducive for the cabal, the corporate state, to make it appear as though there's some sort of insurrection or whatnot that they need to somehow quell. Trust me, the only insurrection is them. That's the only insurrection that we're going to quell. And we're going to do it properly through courts of record, grand jury procedure, and militia. Canon and then military, and I'll get into insurgency. So canon law. So here we go, ecclesiastical, right? This word is taken from the Greek and signifies a rule or law in ecclesiastical law. It is also used to designate an order of religious persons. Francis Durian says the reason why the Ecclesiastics called the rules they established canons or rules and not laws was modesty. They did not dare to call them laws, lest they would seem to arrogate to themselves the authority of princes and magistrates, which of course they don't have. So they can't be considered laws, canons, right? But because of what the Roman civil law did and the cult of Rome, meaning, again, this little section that overlaps the two of them, well, back in these days, the cult of Rome pretty much they were the magistrates, right? They were the people that you went before. And in a sense, they still are, because you're still going before a black robe priest of hell to pray for justice. Okay, military law. Now, I do have a few things in military law, so we can bring them up. So you go into the handouts, and then click on military law. And what I was going to bring up was this aspect of the counterinsurgency manual. I just want to make a little note here and show you, everyone, that the entire federal government is well aware, and this was under Obama's administration, by the way, so make a note of that, that their counterinsurgency of what they're doing right now was laid out in this document, and a lot of other documents as well. But U.S. government counterinsurgency guide. Let's give a guide to the United States government for counterinsurgency, huh? Right. Yeah. Condoleezza Rice, Robert Gates, right? All the scum under Obama. So anyway, I'm not even going to get into all this garbage, but the point is that just to take a look at the table of contents here. Chapter 3, actors. Actors, right? Yeah, actors you pay. The affected government, U.S. county team, international community, right? The private sector, assessment and planning. This is all how they plan to do all this shit. So I'll leave that for where it is, and anybody can take a look at it at their own leisure. Then I have a few other things in here. Law of peace, which is actually a part of military law regarding what the military is supposed to do regarding, say, the wartime's over. And again, I'm not going to get into this, but it was just an example that I wanted to give regarding what military law is. Okay. So military law is the law which governs the Army and Navy and the militia when in active service. And it existed in time of peace as well as of war. It is mainly statutory, which I just gave an example of. It must be distinguished from martial law, which is indeed hardly to be called law at all, even though that's technically what we're under, is martial law from the Civil War. Martial law exists when, for military reasons, for instance, in case of military occupation of an enemy's territory, the ordinary law is to a greater or less extent put into abeyance, and the arbitrary authority of the military commander is substituted for it. Well, as I said, we've had martial law ever since the Civil War. The states are considered conquered territories, and which is why there's all these federal zip codes over all of them. You can look that up in the Buck Act. And that's why there's military tribunals everywhere, where you've got, you're walking into all these courts and having the yellow fringe flags and whatnot. Okay. Yeah, they're running a lot of these courts, a whole mess of these things, all at the same time in each one of these courts. And the reason is because they're doing this is so that if you come along and you maybe squish one or two of the presumptions that say the law merchant's operating under, or that Maritime Admiralty is operating under, right? Or something, or you say, I wasn't in commerce, so the statute doesn't apply, right? They'll have some other jurisdiction running at the same time to keep you there, unless you rebut all of the presumptions, which is, of course, the first course that Vocational Science of Freedom put out, and that's the presumptions class. Because only if you get rid of all the presumptions do you get yourself out of all this peacefully. The other way is just, like I said, down here, military, militia, grand jury, shoot them, which is perfectly lawful as well. But this is everything that I'm showing you guys today is a process to remove yourself from it, to know that you're out of it, to know that it does not affect you over your domain, your dominion, your estate, your children, compared to when we all get together down here finally and have a little party, then it'll be for the protection of our communities, societies, states, so on. So, back to this. So, martial law exists when a military, for reasons, for instance, of a case of military occupation of an enemy's territory, the ordinary law is greater or lesser. Okay, I said that. In many countries, the government has power, even in time of peace, to suspend the ordinary law and proclaim martial law. Or, as it is often called, a state of siege. It's a really good book called Siege, which I highly suggest everybody go read. In the country at large or in particular places, putting them temporarily under military rule, when in its opinion, special dangers threaten the state or the public health. In its opinion. Why does the president have to sign an executive order over and over and over and over and over, meaning president after president after president after president, has to keep signing some sort of executive order continuing what? A state of emergency. Maybe it's because that a lot of things have been suspended since the Civil War. Yeah. Maybe it's because of the enormous overreach of executive power, which has been going on since the Civil War, since Lincoln, which is why if you've ever been to Washington, D.C., and you've actually gone to the Lincoln Memorial, there's a reason why he looks like an enormous emperor sitting on a throne. It's because he was one. So, special dangers threatening the state or public safety, which is basically whatever the hell they want it to be. Oh no, Antifa's coming. Oh, it's a state of emergency. Great. What's this again? Problem, reaction, solution. I'll create the problem. I'll wait for your reaction, like a dumb sheep, and then I'll give you the solution. Okay? That's basically the problem that we're facing in a totality of all this mess. It says, but this is not allowed under the United States or England. Well, wrong. It already has been. Okay, so this gets into maxims. We'll leave that for April. So back to our outline here. Okay, so custom and usage. Okay, let's get into the Magna Carta a little bit. So the common law from an aspect of that. So Magna Carta, the basis of the Magna Carta is, of course, the unwritten law of customs of people. But in a written form, the written form of it is the Magna Carta. And you can find the Magna Carta in the handouts and under common law, and right there. It'll be number 1. The Magna Carta was a document that was signed by King John, who was the brother of William Lionheart. William Lionheart went and did the Second Crusades, basically with his mother, brought mommy along. And her name was Eleanor. So Eleanor was the mother of both John and William Lionheart, okay? So, and the only reason I'm bringing that up is because after John took the throne, is when there was a conclave called. Now, conclave is basically a meeting of the Roman cult. So they all go to Rome and they take their suites with them, meaning their entourages and their knights. And so off they all left. And they did this in the fall of 1214 to go off to Rome. And when the barons realized that little King Johnny was all by himself without all his filthy Roman friends around, they said, all right, enough of this shit. So they cornered him on Runnymede and said, all right, sign the Magna Carta or we'll take your head off. And so he signed it. But the Pope said, well, that's not lawful. You can't have somebody sign something under duress. Okay, fine. I get his point. But the issue was that every single king after King John has signed what's called, again, the Confirmarea Cartarum, which I also have in the documents. So right now what we're going to do is we're going to get into the foundation of the common law, but also, again, this war, to continue with the war between what's called the civilists. The civilists and the ecclesiasticists, which is a long-winded thing to say, but the civilists and the ecclesiasticists are the people that are against, or were the opposite against the common law, the people of the common law, and those that practice the common law in England. And so I want to wrap everybody's heads around what this was, how it came about, and the fight before and after. Okay, so let's go way back for a second. Let's go way back before King John. Let's go back way before William the Conqueror, 1066. Let's go all the way back to when Rome was trying to take over England. So you have Rome pounding along, basically devouring all of Europe, bits and pieces here and there and here, because they were really, really good at keeping slaves. And then means they were really, really good at being able to providing a tremendous amount of money and resources towards their military. And the Roman legions, and not to digress here into military history too much, but it has to be noted that the Roman legions were very good at mobility. They were very good at keeping up with supply lines. They worked very well in units, the way that they fought together in units, basically with their shields and how they protected each other as far as archers go, and everything from that to how the Roman cavalry fought, all that. So they're really good militarily. So they took over a lot of Europe, but the cultures they never could take over were the Celts. The Celts and the Druids, in the Druidic Celtic people of the northern part of England. They pushed them out of the lower part of England, and then they built what was called the Hadrian Wall. And there's a wiki on this. You guys can look it up. And it stretched all the way across England to basically keep the Celts out, because for one, the Celts fought naked, and two, they scared the shit out of the Romans. They Rome, and this of course goes back to the aspect of go watch the unevolved principles of Rome, the consequences of cowardice, and it's all in there. But I just want to bring it up again because you have to understand that the basis of the common law of natural law and preserving society and even preserving nature, which is where you get an aspect of the difference between title. A allodial title comes from the term all oath, right? So when William the Conqueror came over and he created the Doomsday Book, which was a land registry, which destroyed the idea and the customs of title and allodial, even though it's always still there, because allodial means all oath to God. So there was actually a whole poem, a verse, which was called the All-Overful Son, which was the song of the blood in the soil, which you were to go and, if you were to have a allodial title, you had to go onto the land and you had to shed blood onto the land. You had to speak this oath with witnesses. And later, that became the ceremony of what had then evolved into what was called livery of season. Livery of season was this oath-taking event, but it happened between two men that were, one was selling and the other one was buying the land. The transfer of the allodial title. But that's where it stemmed from. So the Druids, the Celts, the Visigoths, like I said, the Teutons, all of the noble people of Europe that wanted nothing to do with Rome, clearly, all had this understanding and connection with nature and with common law, and focused everything that they did based on the love of their people and the love of their land and the love of their lifestyle, to enjoy love and to enjoy life in whatever damn well way they felt they wanted to do it. Where Rome comes in and they say, well, we've got this whole thing, and now you have to register your land with us. And it's like, what? Excuse me? And of course, what Rome was just, like I said, a huge cluster of records and slaves, basically. So that's where you get it started. So there always has been this complete animosity between the common law of the peoples. Now, of course, this is talking about English common law, but of course there was an aspect of the common law of the Teutons, of the Visigoths, of the Celts, of the Vikings, as I spoke about with the Rigmarole. And when you have this fight going on for such a long period of time, all the way through England, the fight really is still going on, because the founding fathers tried to end the fight and more or less did end it through document and a war. But the problem is that we didn't know what to do with it, because there's only been one nation truly in the world that's ever been truly free. It's us. And so, kind of like a new thing that you're not exactly sure what to do with it, it's a little difficult to know how to take care of something when there's been no experience of no one to teach you of prior experience, right, of how to keep the thing in good order. Well, guess what? We're, the third, fourth, fifth, sixth generations down from the totality of this being created. I think it's about time that maybe we lay out or reteach a system that makes sure that keeps this in good order. Because guess what? No one else is coming to save you. No one. Only the people are going to be able to alter and save ourselves. Because it was we the people who decided to say no to the oligarchy and to Roman civil law and to the law merchant, Maritime Admiralty law, and all the rest of this filth. Right? So, as far as the war is concerned, let's get back to the Magna Carta. So as far as the war is concerned, Magna Carta, so you have the barons saying, all right, enough of this registry of lands, enough of this Roman civil law filth. We're going to have our allodial titles back, and we're going to damn sure make sure that our heirs have the right to our estates. So I'm not going to read the start of this. It's just him saying why we're here and why we're doing this. And remember, the barons wrote all this anyway. Number 2, Article 2. If any one of our earls or barons or of others holding from us in chief through military service, that would be knight service, shall die, and if at the time of his death his heir be of full age and owe a relief was what knights had to pay. It was an aspect of feudalism. He shall have his inheritance by paying the old relief. The heir, namely, or the heirs of any earl, by paying £100 or for a whole barony of an earl. The heir or heirs of a baron by paying £100 for the whole barony. The heir or heirs of a knight by paying 100 shillings at most for a whole knight's fee. And he who shall owe less shall give less, according to the ancient custom of fees. Now, this ancient custom of fees in feudalism, this is an aspect of pledging. Okay, this gets into what Edward Mandell House quote was all about, right? Number 3, if the heir of any of the above persons shall be under age and in wardship, when he comes of full age, he shall have his inheritance without relief and without fine. What does that mean? It means you don't get the right to come in here and take what's not yours. When the heir, right, it'd be in wardship. When he comes of age, that means to be able to take care of his own affairs, to handle his own affairs. He shall have his inheritance without relief and without fine. You can't fine me for the use of my own title and the use of my own body. But that's what the filthy attorney is doing right now to all of us under this aspect of Roman civil law and ecclesiastical law being an aspect of probate. And then they say, well, you know, because you haven't claimed it, and they hold the legal title in the aspect of the law merchant of where you create these, where you're constantly paying bonds and fees and getting charged for the use of your estate. Well, why is that happening? Well, it's because no one's paying attention to what the Magna Carta said, and no one's standing on it saying, hold on here, wait, no. When I come of full age, I shall have my inheritance without relief and without fine. Why? Because I'm a member of the posterity spoken of in the preambles of the federal and state constitutions. That's where that comes from. That's the reason why you have that right, is because you're a member of the posterity. Ones who came later, the heirs after. Number 4, the administrator. It doesn't say executor, it says administrator, right? The administrator of the land of such heir, who shall be under age, shall take none but reasonable issues from the land of the heir, and reasonable customs and services, and this without destruction and waste of men or goods. Okay. Why is it that in America we have the highest per capita prison population in the world? meaning there's more Americans sitting in jail and prison per population than any other country in the world. Well, it's because, but we have the nicest prisons as far as prisons are concerned. Well, the reason is because they can't have any destruction to the waste of men or goods. It's in case the heirs actually show up and say, hey, you know what? I don't really feel like being in this prison anymore. I claim my estate and I want out of here. Well, from an aspect of Roman civil law and common law, what do they have to hold you on? Nothing. There's no damage, harm, loss, or injury. All crimes are commercial, and they're all being done under the law merchant. Your mix is like right here. This is literally like the garbage. All the garbage of all the courts happens basically right here. All of it. It's the dead center of this cluster. Screwy. And there's been judges, federal court judges, who have said everyone who's in prison is there voluntarily. Oh, really? Okay. I think the men and women that are in prison would beg to differ. But the reason he said it was because, again, it's a basis of consent, and that you haven't claimed and done what you need to do to say, no, I don't want any part of this system. Okay. But it comes from the administration of the estate. Because your body, you still being considered an infant and not coming of full age, you're still considered to be an infant, and therefore your estate is being administered, right? By these administrators, because you haven't claimed it, or your father hasn't claimed it also. But I cover all that in the presumptions class, so I won't go over that ad nauseum here. So I'll just continue. And if we shall have committed the custody of any such land to the sheriff or any other man, being the attorney or the judge, who ought to be responsible to us for the issues of it, and he caused destruction or waste to what is in his charge, we will fine him. Yeah, I'd like to see that ever happen. And the land shall be handed over to two lawful and discreet men of that fee, who shall answer to us. So every single time that it goes before another judge and attorney, another judge and attorney, another judge and attorney, another judge and attorney, that's just getting handed over and handed over and handed over. The claim is never made. The claim to your estate is never being properly made. That's why it just keeps getting handed over. And why you keep being a ward of the court, right? And if we shall have given or sold to anyone the custody of such lands, and he shall have caused destruction or waste to it, he shall lose that custody, and it shall be given to two lawful and discreet men of that fee, who likewise shall answer to us, as has been explained. So they keep being able to keep it basically under that aspect of control until what? Until the heir comes forward, which is this part. And 5, the administrator, moreover, so long as he may have the custody of the land, shall keep in order from the issues of that land the houses, parks, lakes, mills, warrens, and other things pertaining to it. And he shall restore to the heir, when he comes to full age, his whole land, stocked with plows and wainages, according to the time of the wainage. That's the waxing and waning of the moon, by the way. This deals with planting crops. So according to the time the wainage requires, and the issues of the land will reasonably permit. So meaning, don't destroy the land. Okay. So, long-winded, what Article 3, 4, and 5 of the Magna Carta says is that as soon as you come forward as the sole lawful heir and claim your estate, they have to give it to you. Without fine and without relief, meaning you don't have to pay anything, right? That's what this means. So when we're wandering around here in these inferior courts, not of record, and all they're doing is administering the property of abandoned infants is what they're doing. Abandoned estates, sorry. Well, the infant is also abandoned as well. So your estate's abandoned, the infant itself is abandoned. No one comes forward to claim it after 7 years. Bam. They start administering it, and they keep administering it for the rest of your life, which is why the big, huge, enormous white building next to the White House, in case anybody's ever been to D.C., called the Administrative Building. Does anybody know what date that thing was put up in? It was put up during the New Deal. Why? Because they had to administer all of their infants. And it took a ridiculous amount of paperwork and a ridiculous amount of clerks and whatever, blah, 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 blah. That's where it got started. That building was not there before 1933. Okay? So, you got to pay attention to all this as far as what they're doing. So back to the fight. Okay, so we've got the fight between Roman civil law and common law. So they're beating, and also between Maritime Admiralty as well. From that, let me jump into something else here, just because I want to get the aspect of the fight more understood. So when in England, there was this time where they had this court, and this is, by the way, what I'm going to pull up now. This is under common law, and what we're going to look up and pull up is Court of Wards and Liveries thesis paper. So in the Court of Wards and Liveries was a court that ran from about early 1500s to mid-late 1600s. And what this court did was that it established and dealt with infants and matters of estates when the infants came out of wardship, basically. Okay. So historians have, and this is, I'm just going to read directly from the treatise here, so you get an idea of what this court was, and the fact in the 1500s and 1600s, the English people were still having to deal with this bullshit. Okay, historians have written of the 16th and 17th centuries in English history, such have either made brief reference to the Court of Wards and Liveries, or have all neglected it altogether and have failed to point out just what the court was. In fact, no one has ever given adequate amount of the origin, the purpose of this court, and for the causes which led to its abolition, first de facto and then de jure. Well, I wonder why, because it's a little bit of a thorn in their side as to what the hell they were doing and still doing. The subject is of importance, not only because through this court the king derived a large part of the income during more than a century, but also because the abolition of this court is closely connected with that of military tenures. That's the aspect, again, getting back to the feudal aspect, which goes back to the Magna Carta of Article 3, 4, and 5, which is why I read it first. This study will concern itself firstly with the brief explanation of the origin and powers of the Court of Wards and Liveries, secondly with a consideration of the causes which led to its abolition in fact, and thirdly with a determination of reasons which made it seem advisable to the Parliament in 1660 legally to recognize this de facto abolition. It is not intended to include any discussion of the origin and development of wardship and liveries. Well, we've already covered that, and I'll get into the rest of it. So I'm not going to read this whole entire thing. It's 114 pages, clearly. But what I just wanted to bring up is that this is an interesting document that everybody should read, because you'll get an understanding of what was going on here. Like, the custody of the lands of idiots and of lunatics was declared to belong to the king, and was also the escheat of lands dissenting to aliens. Aliens. Like a resident. If you're a resident, you're not lawfully domiciled anywhere. Or you might have one, but not in the state of which you're saying you're a resident in. Do you know that? That means you're an alien. So the problem with that is that when your land's escheat, take down this word, escheat, E-S-C-H-E-A-T. What you'll learn about an escheat is that an escheat is what happens when there's no heir. No heir to come forward and claim what's lawfully his, to claim title. Now, Blue Star and I found some interesting points in Michigan law, which stated that under the Michigan Constitution, there was once a board of escheats, which then we found out through pestering the state law librarian, which, by the way, is a great place to get information. If you ever have any questions about why you think something changed in your state from the original Constitution to whatever, it doesn't matter. The state law librarians are there to help you. Now, most of the time, I've run into just the greatest people in the world. They've always helped, and they've always sent quickly whatever it is you're looking for. Now, they won't answer, they'll never answer legal questions. Like, they won't give you legal advice, but what they will do is, if you want a specific thing about, hey, where does this go? Or what was the act that might have altered this? Or so on and so forth. That is something that they are absolutely there for and will find for you quite quickly. And so what we found by pestering the Michigan State Law Librarian was that the State Board of Escheats, which was a constitutional creation, had then been moved, altered, put under the state treasury. You're like, wow, that's interesting. And once you understand what the word escheat means, like I said, but go look up the definition, not just the off the top cuff of my brain of what I said. But once you understand this aspect of a sheet, you'll see that, oh, okay, it makes sense that they would have put it underneath the Treasury, because in 1933, all the governors of the states literally committed treason and pledged all of the registered property and land to United States Federal Corporation, which was established in 1871, in case anybody has any question about that, and can be verified under 28 U.S.C. 3002-15A USC, yeah, that they pledged it all so that the United States Federal Corporation could take out loans from a private banking cartel called the Federal Reserve. So now what does that have anything to do with sheets? Or anything to do with the Court of Wards and Liveries? Or any of this? The fact is that what they did was they got their feudal system back up and running by the aspect of pledging. When the children at the foundling hospital get pledged by their mother, unknowingly, by a birth certificate contract, no one ever comes forward again to claim the estate. And after 7 years, the presumption is that nobody will, and you're considered dead. The presumption of death kicks in. That, oh, we don't know where the infant is, even though the mother took them home, but they don't know. They can say, oh, we don't know where the infant is. Oh, must be presumed dead. Okay. Well, that's why when you get your birth certificate, it's on bond paper. That's why a death certificate is on bond paper. Why? Because all of this has to do with the law merchant, how they're moving people through slavery, through the law merchant and Maritime Admiralty and Roman civil law of the administration of your estates, basically for your entire life, because you're not paying any attention to it. So the aspect of the escheat part, right? They consider all the lands in America pretty much to have been abandoned. And they're just waiting, and I've heard this spoken, it's not spoken of anymore, but I heard it like back in the late 90s, early and late 90s, that basically what the judges and the government are waiting for is for us to grow up and claim everything back. And maybe they've gotten tired of waiting. I don't know. Because this whole idea of the global reset is an aspect of them using our credit to create more and more and more and more credit. But because all of our credit has basically been abandoned, and we don't ever claim it back, either on the proper probate record, which is to claim the whole entire state, because we never claim anything back, right? Basically what they're doing is they're considering all of it to have been escheated. Okay. So what were they doing back in England? Well, it's from a standpoint that if the ward didn't come forward and sue out their livery, or didn't have basically pay or couldn't pay an attorney, it was a way of the attorney making sure that they could always keep getting more and more and more money for their uselessness, but that they could create a system where you had to go through them to get your estate back. Okay. Now the thing about the Court of Wards and Liveries is that it wasn't legally abolished until the year of 1660. Well, the thing that this treatise doesn't say anything about, or this thesis paper, is that the Court of Wards and Liveries actually just morphed into something else. It morphed into what was called the Court of Wards. And you can look both these up on Wikipedia, okay? They totally find all this information. So look up the Court of Wards. Well, guess who ran the Court of Wards? The East India Trading Company. This is where you get this supposed official state court, right? Abolished legally in 1666. Well, guess how it pops up again? Under a corporation. What do you have now? You have corporations as courts. Every single court out here is a filthy ass private for-profit corporation. And you can look them up on Dun & Bradstreet. One of the really fun things to do is look up your district attorney. It'll say also traded as Winnebago County, or also traded as, whatever the name of the county is you're in. It'll be his name, but it'll say also traded as such and such county. It's because the county's a corporation too. Because all of it's under Roman civil law and nobody's paying any attention to it. because we haven't claimed back what's ours. So in 1660, they abolished this court, that they created the Court of Wards. And then right after that, guess what they did? They burned London to the ground, right? So, and by the way, another note of history here. Oliver Cromwell was a filthy Luciferian scumbag who never had any authority whatsoever. During the quote-unquote English Civil War, he overturned the Edict of Expulsion, laid down by Edward I, also known as the Hammer of the Scots, who was portrayed as Edward the Longshanks in the movie Braveheart. Well, guess what? Edward I laid down an edict of expulsion where he expelled all Jews from England under pain of death. He was sick and tired of their bullshit. Well, guess what? After Oliver Cromwell overturned the Edict of Expulsion, which of course, like I said, he never had the authority to do, within 10 years, the Court of Wards was created under the East India Trading Company. London was burned to the ground. 70,000 people died. And in 1666, they implemented the Sestri Que Vi Act, which said, unless you come forward and prove you have been found to be living in an action, the Crown, which is also another corporation, run by the same Luciferian scumbags, gets to keep everything that you own. How convenient. So they took care of England pretty quick, didn't they? Right? And of course, Rothschild was in full control of the Bank of England already, which is, of course, that was the whole thing. I mean, it became the country of Rothschild. It became the country of the Luciferian scumbags being run out of the city of London. That was what, I mean, if you truly want to get down to it, that was what the English Civil War was about. It was about letting the Khazarian mob take over all of England. And of course, by force, fraud, lies, and coercion. But on a side note regarding that, the Edict of Expulsion, because Oliver Cromwell never had any authority to overturn it, technically it's in still full force and effect as per common law in every single common law nation. So, yeah, just to think about that as an aside. So this is the war where it started from a standpoint of the Court of Wards and Liveries, right? Okay, so what we had back then from the Magna Carta was said, no, you can't do that. They come in and do this, they change it, and then they burn London to the ground, and then they bring in the Sestri Que Vi Act. So that's the Court of Wards and Liveries for you. And from a standpoint of the war between, now I'm going to shift a little bit here. What are matters that are adjudicated under common law? So this is okay, let's get into this. So the things that are adjudicated under common law, harm, right? Talked about that. So damage, harm, loss, and injury. You did this, did that, did this, did that, right? Okay, that's a harm. Also called torts, which I'll put in here. Torts. Lawful contracts. So what's a lawful contract? You got to have lawful consideration. No worthless Khazarian mob garbage notes. Entered into knowledge that you knew what you were doing. So meaning you can't have one-party contracts. And you also can't say, well, we signed that for you. Another aspect of signing things for you. When it comes to being in these filthy law merchant courts, what they'll do is what the attorney will do is that they'll create bonds, billions and billions, well, trillions, you know, consider the whole planet, of bonds, and they'll do it by power of attorney. So what that means is that the attorney will sign the bond into existence, right, for you. How convenient, right? So they, by power of attorney, bond the case, of which you're never aware of. And the other thing you're never aware of the fact is that if you were to get a hold of the bonding information, which we have a process to do that at the Vocational Science of Freedom, to be able to get a hold of the bonding information, you can then contact the bonding company and cancel the bond. If you don't have a bond, they don't have a case. Now, there's another gentleman who does something slightly different, which I do eventually want to get a hold of him at some point in time, figure out exactly how he did this one. But Cal Washington, instead of canceling the bond that they have, what he does is he bonds his own case. He brings a court of record, but he bonds it himself, which goes back to what I was talking about in ancient Rome and also in England, when it's called a wager of law, right? So you're putting an amount onto the conviction of your truth. And what Cal ends up doing, what Cal will do is he'll bond the case for like $300 million or some ridiculous amount, right? Well, not ridiculous, because honestly, truth be told, all of us have a bond attached to our birth certificate that's sitting at Fidelity. And we know this because we've done audits through Bloomberg terminals to determine the CUSIP numbers of these bonds. And most of them come back between 130 and about $300 million. Now, some people say, oh, mine's a couple billion. Well, what you're not paying attention to is that what you have to do is divide that by 12 because it's in a tranche. The one CUSIP number is for the entire tranche. So what you have to do is actually ask for, and you do this to the broker, is demand the broker give you there's a specific name of it, but it's basically the specific CUSIP number for your specific amount of the bond, not the totality of the bond itself. So anyway, so all this bond and bonding, all this law merchant garbage, that's how they're doing all of these courts, right? And in Maritime Admiralty law, it would be considered, or used to be called, or actually it's still called, a bottomry bond. And a bottomry bond is a bond that you take out basically on the bottom of the ship, whilst the ship is doing whatever it is doing out in the high seas and yada yada. But it's an insurance policy. Okay, so all insurance policies, as I've stated before, but I'll state it again, all insurance policies are adjudicated under Maritime Admiralty law, all of them. I don't care if the actual insurance policy is on the land or not, they're all adjudicated under Maritime Admiralty law. Okay, so what they're doing is they're entering you into contracts, into bonds, into the system that you don't even know about. Well, how's that lawful? Well, it isn't. But from the standpoint that you're an infant and you haven't claimed your estate, can they do it? Yeah. Once you understand how all this works, yeah, they kind of can do it because you're not claiming your estate. You're not coming forward as a member of the posterity properly. You'll screw up something somewhere. I can guarantee it because you won't crush all the presumptions. Like somebody might say all the right thing and then the judge will say, are you a citizen of the United States? And they'll say, yeah, of course I am. I have my civil rights. The judge will say, you bet you do. Get your ass in jail, you moron. So anyway, C, from the aspect of lawful contracts, under the outline. So C, it cannot be for an unlawful act, meaning you can't create you can't create a contract regarding an act that would be unlawful. As an example, a license to kill somebody, or to write out a contract and say, hey, Joe, I'll pay you $10,000 if you go kill my neighbor. Right? Can't do that. It has to be two parties. You can't have a one-sided contract. Now, what you can have on one side, and this was confusing people for years, or I noticed it was confusing a lot of these patriots for years, was that a pledge can be one-sided. And that's what everybody wasn't paying any attention to, is the fact that they're doing all this by pledging, not necessarily all by contract. It starts with the pledge at the Foundling Hospital, okay? And the finishing off of that pledge with the contract of the BC. And then it gets cured or perfected because of the fact nobody comes back to claim your baby, but in 7 years. Which technically the father is supposed to because he even gets an announcement in the newspaper to come do so, but he doesn't do it. Yeah, that's not a joke. That's actually how that works. And then number 2E, you can't have a contract under duress. So I haven't agreed to if somebody puts a gun to my head and says, here, sign this. Well, is that a lawful contract? Nope. Is that what, I think it was Pope Boniface, but don't quote me on that, said about the Magna Carta? And the answer is yes. He said that's a contract under duress. Well, like I said, that gets back to the Confirmare Cartarum, or the confirming charter that every king has signed after King John. So it kept on going anyway. And then F, you must have capacity, meaning no infants and no lunatics. So what did I just show you in the Court of Wards and Liveries thesis paper? Well, it was talking about who has control of infants and lunatics. Well, the king does, or the attorney, because now you have the English Empire has always been under the Rothschilds, in case anybody had a question about that. It's why England became an empire. And I think it was one of them, I don't know which scumbag Rothschild it was, but one of them said, the world, I'm going to paraphrase this, it's not going to be exact, but it's something like, the empire of which the sun the empire upon which the sun never sets is controlled by the one who controls its money supply, and I control the English money supply. Or something to that extent. He's basically saying that he ran the entire, that the Rothschilds ran the entire English empire because they ran the money supply. And guess what? He's right. And the only reason that Napoleon got beaten back was from the Battle of Waterloo, and that was a creation from the Rothschild agents running information back to England to say that the English had lost when they really won. And they sold, then the Rothschilds started selling off everything as if, the English were going to get invaded and lost. So everybody else started selling everything off too. And then the Rothschilds started to buy everything back up. And they bought everything back up. And then the real news came in that the English had won, and the prices skyrocketed. That's how you get a bunch of Luciferian scumbags to own the world. One single event. I'd say it's about time we take it all back from them. But anyway, I'll get off my soapbox and we can take a break here. Let's take a break, and then we come back. Let's come back at 4:30. And when I come back, we'll get into the fight between common law and maritime admiralty.